Emma Mijas died a horrible and painful death unnecessarily on her very first Christmas Eve 2004 at the hands of 25 doctors and nurses, another victim of medical malpractice. All 25 doctors and nurses systematically administered the wrong drugs for her life-threatening condition called SLOS. SLOS, Smith-Lemli-Optis syndrome, is a congenital abnormality which requires treatment strategies on supplying supplemental cholesterol. They gave Emma the wrong drug, Questran, not once, but 92 times. Yes, 92 times in 1 month. A cholesterol-reducing drug, not the cholesterol supplemental drug she needed. All of them knew better. They were trained to know better. They were some of the world's leading authorities at the Louisiana State University Health Science Center in New Orleans. But they just didn't give a damn about Emma's life. In 2013, the prestigious Journal of Patient Safety published a study that as many as 440,000 patients die each year from preventable medical errors. That would make medical errors the third leading cause of death in America, behind heart disease and cancer, which is second. These people are not dying from the illnesses that caused them to seek hospital care in the first place. No, they are dying from mistakes that hospitals could have prevented. What are these fatal errors? Who are these incompetent and negligent doctors? A New England Journal of Medicine, January 28, 2016 study reported that 1% of physicians accounted for 32% of paid malpractice claims over the last 10 years. The ugly truth is that little is being done to hold these dangerous doctors accountable. Researchers found that bad doctors showed distinctive characteristics, including having paid previous malpractice claims. So it stands to reason that healthcare providers could eliminate 1/3 of medical malpractice along with patients' pain and suffering, as well as the added cost of corrective surgeries, long-term care, and indemnity payments by removing the worst 1% of doctors. Why aren't bad doctors stopped from practicing? The answer lies, at least partially, in the National Practitioner Data Bank, a clearinghouse for information on medical malpractice that Congress established in 1986 to help state licensing boards police the healthcare industry. The national database was supposed to help states identify dangerous doctors and prevent them from harming more patients, and is used by hospitals, insurers, and licensing boards to track doctors' records, check prospective hires, and make other decisions. But it is virtually useless in holding doctors accountable because, by federal law, none are listed by name. They are assigned a random number to protect their identities. Even if doctors were identified in the data as they should be, the public would still be barred by law from accessing the records. So vulnerable, sick patients sit in the waiting rooms of bad physicians without a clue about their poor record of performance. And in many cases, a negligent doctor's insurance company pays the victim of malpractice and the doctor goes back to work. If a doctor develops a bad enough reputation in one town, he can move to a new state and continue practicing. This is unbelievable. But today, the public does not have access to the database to identify doctors' names and addresses, to identify doctors with uniquely long histories of being sued or disciplined for medical malpractice. Because on September 1st, 2011, the government cut off public access. What was behind that decision? Apparently, one Kansas doctor with a trail of malpractice suits, Dr. Robert Tenney. The Kansas-based doctor complained to the Government Health Resources and Service Administration that the Kansas City Star newspaper was publishing the story of one of his patients, Mary Beth Chase, who died in 2007 after undergoing a brain surgery with Dr. Tenney. It is also noted that Tenney has been sued at least 16 times for medical malpractice, but had never been disciplined by the state's licensing boards. The Insider Exclusive produced a TV story on this case with the lawyers who represented Mary Beth's family when doctors go bad, Mary Beth Chase versus Dr. Robert T. Tenney. Tenney finally settled the Chase family's wrongful death suit for $1 million. The settlement brought total malpractice payments paid on Tenney's behalf since the early 1990s to roughly $3.7 million. In some states, including California, Colorado, Georgia, and New York, patients can go to medical boards' websites to find out about doctors' malpractice histories, but not in Kansas and Missouri. Why don't doctors report on bad doctors? Physicians often see the mistakes made by their peers, which puts them in a sticky ethical situation. Should they tell the patient about a mistake made by a different doctor? Too often they don't. Why not? One reason is that doctors depend on each other for business. So a physician who breaks the code of silence may become known as an informer or snitch and lose referrals, a financial penalty. Doctors also may be wary of becoming entangled in a medical malpractice case or causing a colleague to face legal consequences. The bottom line, too often doctors aren't learning from errors, nor are patients getting the information they need to receive proper treatment or compensation when the outcome is harmful. In this Insider Exclusive Network TV special, America's Medical Malpractice Crisis, What You Need to Know, we visit with Mark Davis, partner at Davis, Levin Livingston, as we take you inside today's legal system, examining lawyers' strategies and clients' thoughts, and in vivid detail, showing you the often heartbreaking stories of these clients, dramatically demonstrating what motivates Mark to fight for his clients' causes. Here's just a few of the stories of many victims of medical malpractice that the Insider Exclusive Network TV shows have featured on Network TV.
When the doctors gave me the choice and the options on the table, either to save her life or to let her pass and peacefully without no pain, it was a small chance that she might live after surgery. But I chose life because I think that anybody deserves a fighting chance. So I decided, my wife and I decided to go ahead with the surgery and give her the chance to fight herself. My daughter Malia is special because she has a positive outlook on life in general, on how well she can accomplish things, how she's not different in any other way from anybody else besides the fact that her legs are metal. When I realized that this could have been possibly avoided by doctors seeing my daughter sooner, of course I was very angry. But I was also focusing on my daughter's condition at the present time. But it also made me think a lot about myself if I would have, demanded her to get attention sooner. I mean, there shouldn't be these things where we have to look back on it now and say, I wish I could have done this different. I wish I would have done this. Well, my daughter doesn't get that choice anymore. She has to live with this for the rest of her life. So hopefully this would be a learning experience for the doctors. That's why I would forgive them and tell them that, Amy, just get better at what you do, or pay more attention.
She was a tremendous life, unbelievable energy. She threw parties and she had people over, and she always made dinners for anybody who was sick, and she got involved in every campfire girl, Boy Scout.
She was very capable, smart, giving, dedicated to her children, dedicated to me.
And I kept saying, Mom, what's wrong? What hurts? And she says, my abdomen. And she was miserable. And we said, well, please call a doctor. She needs to be examined. We asked him 3 times.
The nurse said they'd call the doctors. The doctors were aware of the problem, but the unfortunate part about it is the doctors never showed up.
And that's when I reached down and hugged her and I said, "We're here." And she opened her eyes.
When the doctors told me that I had to make a decision for my husband's amputations to survive or just let him go, that was very difficult for me. I had to think about it and pray about it and talk with my family. It was a hard decision and life-changing.
My wife has been an angel. She's stuck by me. She's done everything for me. My mom, my sisters, my brothers, my kids. Without them, I wouldn't have made it.
Dr. William J. Irwin failed to comply with the appropriate standard of care for an OB/GYN in the year 2007. And as a result, Rebecca Gatti, a newborn baby, suffered severe brain damage which is lifelong and irreversible. Those brutally frank words were how the Louisiana Medical Review Board explained to Ryan and Susan Gatti, the parents of their new baby girl Rebecca, why Rebecca had suffered irreversible brain damage due to the incompetence of Dr. Irwin, and now will require round-the-clock care for the rest of her life with no chance whatsoever for improvement.
Well, on the day that I gave birth to the boys, I was very scared. You know, it's first time you're getting all ready to your life to change. In the delivery room, they would monitor me and they had all this equipment on me, and then all of a sudden, when he pushed down on my stomach, when the placenta blew away from the uterus, I let out this really loud scream, and it was very painful. And then I just looked at my sister and I knew something was really wrong. I first realized something was wrong with Hunter. Well, he was in the NICU for a week, 8 days. And when he got released, they had told me that Hunter was going to have learning disabilities and he might be dyslexic, but they never mentioned that he may have cerebral palsy. If I had a chance to talk to the doctor today or directly to him, I would say, how dare you? How dare you take away the life that I was supposed to have? And how dare you do this to Joshua?
What I miss most about my mom are the holidays. The house was transformed. My biggest challenge with my mom gone is trying to step in her footsteps. Doctors who are not qualified to perform certain procedures, their license should be revoked. Dr. Jacobowitz, I don't have words. I don't have the words to express what your actions has done, the pain and the suffering that it has caused that can never be reversed.
These are just a few of the real medical malpractice victims who have dealt with our legal system victimized by bad doctors. This is why we all need to protect a legal system that is designed to protect us, and not one that protects incompetent and negligent doctors, nurses, hospitals, and their insurance companies over the common everyday American. Mark Davis, partner at Davis, Levin Livingston, our featured lawyer, has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Hawaii. He has seen many innocent and hardworking people injured and die as a result by negligent and incompetent doctors, hospitals, and nurses. His passion is problem solving. He approaches each case as a scientist trying to solve a puzzle. He has seen many patients suffer needless injury, and because of that, he's driven to help people who have been harmed by incompetent and negligent doctors. His goals? To get justice and fairness for injured people, safeguard victims' rights, and to help guide the hands of justice. This is the Insider Exclusive, live from Honolulu, Hawaii. It is my great pleasure to introduce Mark Davis to the show. Welcome to the show, Mark.
Thank you very much.
Tell our audience a little bit about your firm, what type of law you practice, a little bit about yourself.
The firm was founded 40 years ago, a little over 40 years ago. All four of the founding partners had come from public interest backgrounds. I was a civil rights lawyer with the ACLU. Another partner was with Legal Services. Another partner was with National Prison Project for ACLU, and another one was executive director of Common Cause. So we all had this experience of, using litigation for the public interest. And when we decided to move into private practice and handle private cases, we always felt that it was important for us to continue to maintain some of our public interest work. So we continuously have a group of civil rights cases and public interest cases that we pursue. And more so, we have tried to select the cases that we've handled over the course of 4 decades to cases that might have an impact to change the way things are. And that's one of the big issues that we have felt has been so important in the tort world, is that you're able to perhaps make a difference with regard to how issues with regard to safety and medical practice and so on may be changed permanently. And that's been, personally for me, one of the more satisfying aspects of practicing law is the idea that what we do we're invested in because we feel it's important and has an opportunity to change.
I understand also that one of the organizations that you were the president of before, and the only member, by the way, of the bar from the state of Hawaii, was the Inner Circle of Advocates,
That's
right?
correct.
What do they do, by the way?
So this is a group of, I think, who are probably the top plaintiffs' lawyers in the country, some of whom are civil rights lawyers, some of whom do all sorts of work. But they are lawyers that are not litigators in the sense that they never go to court, but these are trial lawyers, the people who really make their living inside the courtroom. And it's a collective group in which we share strategies and ideas and also friendships. There are the people in this group that are some of my closest friends, people that I would do anything for, they would do anything for me. And we are constantly consulting on how to do a better job, how to hone our skills. And that's kind of the meat of the issue. It's not a political organization. It's all about, improving your lawyering skills. And it's been a great honor to serve that organization as president and to, as of today, continue to be an active member.
Mark, tell our audience, you hear this term medical malpractice. What's it mean? How is it defined?
Well, it's it imposes on a standard on healthcare providers. The same standard you have when you're driving a car. When you come to a stop sign, you got to stop. When it's a red light, you got to stop. You got to blink when you change lanes. These are standards that are articulated either by common use or common law or by statutes or regulations and so on. That also applies to healthcare providers. There are standards, and it's commonly called the standard of care, which is a practice articulated by the profession that says under certain circumstances you're required to comply with what the appropriate reasonable standard is to do certain things, whether it's diagnostic procedures or various types of interventions. And when one fails to do that, just like you would fail to stop at a stop sign or a red light, or you are held liable for the damages that are caused by your failure to comply with the rules of the road, the rules that you have to live with in order to practice your profession.
When you have a loved one in the hospital that dies, and the doctors come out, the nurses come out, we're sorry, you know, this happened, we did everything we possibly can. How do you find out whether they did everything they possibly could and whether they followed proper procedure? I mean, that seems like a long jump from waiting in the waiting room to what happened in the operating room.
Well, I think that, you know, you would, maybe you wouldn't be surprised at the number of calls that we get in our office that somebody died and nobody ever expected them to die. And they just got a phone call in the middle of the night and they were in the hospital. And they presume that by virtue of the fact that the death was unexpected or the injury was unexpected, that there must have been some medical malpractice. And one of the real difficult conversations I've got to have with a lot of potential clients is that there are certain things that go wrong that have nothing to do with the violation of the standard of care or the negligence of the doctor. There are things, and often that can cause death or serious injuries. So what you have to do, what one has to do in order to really, you know, dig down to investigate this, and often when a death or an injury is untoward or unexpected, it requires an investigation about what did indeed occur. We have a, you know, full-time medical staff that works with us to help us dig into this. And the first thing, of course, is that you do is that you have to get the relevant medical records, the discharge summaries, the autopsy, and to try to start digging what actually occurred that resulted in this incident. Often they tell the story, but many times they do not. So in addition to the initial evaluation of what occurred, including all underlying and prior, you know, medical conditions that may have impacted it, you also have to, you know, give it a kind of a special scrutiny, you know, like reading the records and saying, wait a second, this doesn't really make sense. This doesn't jive. And fortunately, we have a team of people in our office that is extraordinarily skilled at not only reading what's on their medical records, but also reading between the lines. And that's the kind of thing that then initiates a further investigation.
I am informed that roughly 3% of doctors cause 30% of the medical malpractice errors. My question to you is, being here in Hawaii, and probably handling most of your medical malpractice cases here, you must be familiar with some of the hospitals, some of the doctors that keep coming up on the radar, okay? And that plays into whether you're going to continue to investigate a case and maybe take it on, correct?
You know, I think that's true. I mean, and, you know, our suspicion is often triggered by certain, you know, institutions and individuals that we see coming up time and time again. We've had cases in which we've, you know, had kind of what we think is a rather egregious violation of the standard of care, and no longer do we get close to kind of resolving that until we have almost an identical case by the same physician that comes into our office that we, you know, have to, you know, evaluate. And it triggers, you know, a relatively new area in this world, which is claims of credentialing error, credentialing negligence. That is, a hospital is kind of the gatekeeper. Before any physician is authorized to walk into the operating suite or to practice within a particular hospital, the hospital has a credentialing committee and has to look into the background, judgment, competence of every physician. And often, when there are, you know, episodes that are tragedies, there are procedures that are triggered in which the hospital has to look into it, the quality assurance, and it's not the type of thing that can be used in a malpractice case, but it is an internal requirement compelled by federal law to make sure that the hospital monitors the conduct and events that occur within their hospital, and that triggers often a inquiry into the credentialing, which may require them to take action, which might prevent the second thing from occurring. So we as lawyers are looking at this more and more.
As you were talking, I'm thinking, well, the hospitals have the same problem that you and I would have if we were looking into a doctor. For example, one of the cases that you handled, Dr. Ricketson, he had been dismissed, or he had his license revoked in a number of states. When this happens to a doctor, because we've seen this time and time again, where a doctor is allowed to resign his license in a state, so no disciplinary actions being taken against him, moves on to another state, and they're unable, the hospital or anybody else is unable to find out what happened to this guy. Why did he make a move? So I see the hospitals running into the same problem that you or I would have, correct? Or you as a lawyer would have, in looking as to see why this particular doctor, surgeon, nurse was able to get a license in a particular state.
Partially true, partially not true, because a credentialing committee often has the ability to contact other hospitals, get the files from the physicians. And if there are, medical catastrophes that implicated this doctor, often that shows up. In addition to which, if there are publicly filed lawsuits, maybe in recent days, you have the ability to, track that down as well. In addition to which, of course, there's the National Physicians Database. And by federal law, if you are involved in a medical malpractice claim, it must be reported to a basic database. And often that is one of the big incentives that physicians have to try to conceal these cases and not worry about them, because they don't want to be reported to the database. And there's a variety of ways that, I've run across that hospitals and employers of physicians that are liable for malpractice, try to avoid the reporting requirements.
What if a case is settled confidentially? Is that reported?
Our role, representing the patients and being the attorneys, we have no involvement in actually doing the reporting. And so it's always an obligation of the physician, the employer of the physician, or the hospital to make the report to the national database. And whether that's done or not is probably a very interesting inquiry that could be made, because obviously the physicians do not want to be reported. Employers, big groups that employ a physician, don't want to be reported, and hospitals certainly have an incentive not to report. So, it's a problem that I really don't know whether it's monitored in any significant way, but it does appear to be a factor in when people, are facing a courtroom and recognizing that a verdict is going to unquestionably be reported in the national database.
Getting back to what I spoke earlier, 3% of the doctors, currently licensed doctors, create 30% of the medical malpractice errors. It would seem to me that the good doctors would want to get rid of the bad doctors. Why is the medical profession, or is it the insurance industry, so protective of doctors?
I think that, there is a guild professionalism that, tends to subscribe to kind of a code of silence. The doctors together, when they're on the golf course, may talk about a particular physician and what he's like, but trying to then air that in the public in any manner that would implicate, anybody else, as you certainly know and may have heard of, that often it's very difficult to get a physician to testify against another physician in the same community, which is why most firms in my position always go to the large medical schools and to provide their experts to testify against them. That used to be a proposition that was ingrained in the law, because often many states would require that for there to be expert testimony for a violation of the standard of care, it had to be from another physician from the same community. And ultimately that has been kind of abandoned by virtue of the fact that, and a recognition that people are all trained by the same national medical schools. So there are national standards that should be employed. So that's a little bit of a vestige of a guild attitude to protect your colleague. And I think that some doctors don't subscribe to that, and are prepared to come forward and say, this has got to stop, and I'm going to tell you what I know about it. And so that's always been kind of an ongoing problem, and it's those people that stand up and can, candidly and honestly talk about errors. They're the ones that are contributing to improving the system and protecting the public.
If you suspect, and this is directed to our audience, if you suspect that you may be a victim of medical malpractice or someone in your family, what should you do?
Well, I mean, I think the first thing to do is, if you find, you need to track down a lawyer who's prepared to, investigate it.
Can you get your own medical record?
Yeah, you can. Everybody has a right to get their medical records. That's enshrined in law. There should be no question about it, but often there is, because we have found that when individuals, that two things happen. That when a lawyer, requires a request of medical records, then a report is immediately made to their what we call the lawsuit department, but it's their quality of care department. And often they have people going through the records and making determinations whether there's something in the records that are going to expose them to liability before they're produced, and so on. The other thing that we found is often that when a patient requests their own medical records and they are they don't have a lawyer, that often the hospitals won't give them.
I thought you said it's enshrined in law, though.
Well, no, it is absolutely.
But they're not.
But they delay, and they. I mean, we've had a case that we were dealing with last week, where someone had passed away, and they had, and they wouldn't give them the autopsy, and they wouldn't give them this record, and they wouldn't give them that record, and we ultimately, confronted them, and they were trying to get it all themselves, and as soon as they realized there was, a lawyer involved, they understood that they had to comply with the law, and then they produced everything.
What are probably the most common types of medical malpractice errors?
I think there's a failure to diagnose. I think we see that, a lot. There's signs and symptoms that, should be big red flags about, what was going on. There is a delay in treatment. Often that, there's some situations that require, immediate intervention and so on, that for a variety of reasons, because the doctor's on vacation, because somebody's not on call, because they want to just wait and see if things get better magically by themselves. There is, often a delay associated with the intervention and treatment. And then there is just a lot of, simple errors, mistakes. They misread the x-rays. They misread the laboratory results. There is a, dangerous report from a test that was given that nobody paid any attention to. It gets caught in the file. Nobody gets called. The patient didn't get called, and it just slipped through the fingers of the people that are supposed to be evaluating.
In the state of California, a very blue state, we have a cap on medical malpractice, non-economic damages, pain and suffering, which is limited to $250,000, signed into law 46 years ago by a Democratic governor by the name of Jerry Brown. And over the last 45 years, it's capped at $250,000. The problem with that cap is there's two types of damages. There's economic damages, what you lose by the fact that you can't do what you used to do anymore, right? And non-economic pain and suffering. If you have no economic value, you're unemployed, you're a student, you're retired, the byproduct is many lawyers won't take those cases. And the reason they won't take these medical malpractice cases is because it costs them maybe $100,000 to prosecute a case.
Hundreds of thousands.
So if you got a max of $250, and even if you win, you lose money or you work for free, right? Which is very unfortunate. So in 2016, it was on the ballot again about increasing the value of the non-economic damages in the state of California from $250, I think, to $1.2 million. And it was defeated 2-1. And one of the big marketing organizations that defeated it was the insurance industry. And they said, you know, it's those trial lawyers again. They're filing frivolous lawsuits to get jackpot justice. What do you want to say to them?
Well, I think that, you know, one of the values of the tort system, which goes back, you know, to the most basic system of compensation, which you find in the Bible, you find in the long history of Anglo-American jurisprudence, the idea that one is compensated for the injury, not only provides a system by which people are appropriately and fairly compensated, but it acts as a deterrent for misconduct. And if you remove the ability to hold wrongdoers accountable, then you remove the whole deterrent effect of the judicial system finding error. And I think it gives hospitals, and that's exactly what insurance companies want, to eliminate the any liability. And I mean any liability, because these are cases that, even though they may have a modest cap, they're simply uneconomical to pursue. They get a free pass on whatever they do. The insurance industry, and especially the medical malpractice insurance industry, do not want to eliminate medical malpractice, because that would eliminate the need for insurance. They just want to be able to collect the premiums and not have to pay the damages that are suffered by the victims.
Interestingly enough, one of the arguments that was made 46 years ago in the state of California, and many states, regarding the tort system, tort reform, tort deform, was the fact that, hey, these lawsuits are getting out of hand and driving up the cost of medical malpractice insurance. Well, in states where they did actually pass caps, like Texas, like California, and various other states, the insurance premiums still went up. Why is that?
Honestly, you know, the insurance industry is in it to collect the premiums, and anything they can do to ensure that that goes on, especially if they eliminate the obligation to pay any benefits, is something that, you know, you don't have to be a rocket scientist to figure out what their interest is. And so the whole, you know, movement towards tort reform is something that is, you know, an economically inspired movement, and it's something that often appeals, you know, to people who are not injured. You know, nobody likes lawyers unless you need a lawyer. And that's when you come to recognize the value of the system and the value of having somebody, a counselor, who can assist you in the information and advice and guidance that you need.
Which brings up one final point here. You mentioned you have a medical staff. You have a staff of people that are familiar with medical malpractice cases, et cetera. There's a lot of law firms that say they can do anything for you. Okay? They'll hold your hand, they're going to get the best results, all that sort of thing. But having a medical staff on hand, what does that mean at your law firm?
I think it gives us the facility. And, you know, our people travel around with our lawyers and sit right by their side during their deposition. And, you know, they're able to take a look at, you know, during the course of any examination or a trial when something, you know, doesn't make medical sense. And it just gives us a leg up. And often many of the big defense firms has a, you know, similar thing. But the biggest issue that is the most effective tool in pursuing these cases is the ability to try a case. So many people and so many firms that are involved in litigation and often do medical malpractice never try cases. It's more and more difficult to get to trial. People are more and more moving away from having the skills associated with trying a case. But when you have an ability to try the case, and you are known in your community for being willing to go into the courtroom and try a case if it's meritorious, that is the most efficient tool that you have in your quiver that's recognized by the defense lawyers you constantly run against, the insurance companies that you've been up against. They know who the people are that will try cases. So were I in advising somebody about the selection, you want to make sure that these are people that don't just settle everything, but people that understand that they got to try cases. And that means people that win cases and lose cases. And if you ever have lawyers that say, I've never lost a case, you have somebody that's not trying enough cases. And those are the two things: having a good, strong medical, bench that helps you evaluate these cases, and have a group of trial lawyers that are skilled enough and brave enough to go in and try the cases.
When you look at all the cases that you have tried over your career, what gives you the greatest sense of satisfaction in trying cases?
It's kind of difficult to describe the personal satisfaction you have when, in the course of prevailing in a case, that you have a toddler or a person whose life is going to be materially different by virtue of your success. And, as you have these cases, these people are not just names on a file. You are part of their lives, and they are part of your life, and you are at their house, and you are at their bedside, and you understand them as humans, and your heart goes out to them with regard to what they suffer. And it's something that you can't do just by looking at a file with a name and a description, but it's that connection. And I have a colleague of mine that actually goes and spends the night at the house of their victims. They want to understand their life. They want to live next to them a day by for a full day to see what it's like. And that's the thing that inspires you to fight so hard for these people. And it's the thing that ultimately, when you're successful, gives you the personal and professional satisfaction that makes all this worth it.
Well, we wish you continued more success in your medical malpractice cases, and thank you very much for being on the show.
Thank you very much.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.